A very warm welcome to Lawvs first National Moot Court competition. We are honored to have our learned judge in this courtroom, Vipul Singh, as a judge. We welcome you, Lordship. Before starting with the argument, we would like to brief the bench about the functioning of the courtroom. I, Prakhar Sharma, will be serving you as a court master and will be assisting you with maintaining the decorum and to assist the honorable bench. The court master will act as a facilitator between the bench and the counsel. The court master will time the arguments and intimate the bench accordingly. Your lordship is requested to please seek our assistance whenever it is required, as stated and rule of Law BS First National Moot Court Competition 2025 are each team will get 25 minutes to represent their case, including 5 minutes will be given for rebuttal and sub-rebuttal, subjects to the discretion of the honorable judge. Each team shall intimate the courtmaster in regard to division of time between the speakers. Only one speaker from each team shall be permitted for the rebuttal and sub-rebuttal. The order of presentation is petitioner is speaker number one, petitioner speaker number two, respondent speaker number one, respondent speaker number two, rebuttal petitioner, any of the two speakers, sub rebuttal respondents, any of the two speakers, where sub rebuttals will be permitted only at the discretion of the honorable judge. The judges may exercise discretion for extending the time for the oral round beyond the time specified in the rule book. The rule book provides that the time extension up to 2 minutes is permissible for each round. The team code for the petitioner is TC31 and the team code for the respondent is TC06, Cooperative School of Law. And first one is the Indian Institute of Legal Studies. The total time is 50 minutes. Vipul Singh ji,
Hi Prakhar, how are you?
I am
Can you
fine,
hear
sir.
me?
Yes, I'm
Am I
getting your
both
voice.
audible and visible?
Yes.
Yeah, perfect, perfect.
Shall
Hi
we?
everyone. This is Advocate Vipul Singh. I'll be I'm actually honored to actually adjudicate this present preliminary round of this current moot. I'm wishing you all the very best. Try to be precise, try to articulate your arguments, and wish you all the best.
Let's start the competition. And first team will start the arguments.
Prakhar, TC06 is the respondent, correct?
Yes, Cooperative School of
Okay,
Law. And TC31 is the petitioner or plaintiff.
okay, perfect.
Okay.
Yeah, we may start. Yeah.
A very warm afternoon to your lordship.
I can't see you. Yeah. Yeah, now you're both audible and
Am I
visible. Yes.
audible?
Yes.
No problem, Your Lordship. The council seeks permission to start with the jurisdiction of the statement.
Allowed. Yes.
The council, on behalf of the petitioner, most humbly and respectfully submits to the jurisdiction of the case before the Honorable Supreme Court of India under Article 136 of the Constitution of India, which is specially to appeal by the Supreme Court. This memorandum sets forth the facts, laws, and the corresponding arguments on which the claims are based in the instant case. The petitioner affirmed that they shall accept any judgment of this Honorable Supreme Court of India and shall execute it in its entirety and in good faith.
In the meantime, can we just hold the proceeding for 2 minutes? Prakhar, can
No,
you
no issues, sir. No issues.
do you have my number?
No,
No,
I
you do not have my number.
yes.
So can you please call me once? I'll just tell you my number.
Okay. Wait for a second.
Yes.
Yes, tell me.
It's 7217 646
7217646
646 149.
149. Okay, I'm calling you.
Guys, I'm so sorry for the interruption. We'll be back in just 2 minutes. Yes, hi, TC 31. We may start with the proceedings. So we were at facts, correct? Hi, can
May
you
I
hear
please
me?
this honorable your lordship, shall I start?
Yes, yes, please, please.
May it please this honorable court. This appeal arises from the Bang Bihari Temple Vrindavan, temple that has spiritual and cultural significance for millions of devotees across India. Every year, nearly 50 lakh pilgrims visit, and during festivals like Janmashtami or Holi, Vrindavan becomes a sea of faith. The temple and its precincts are centuries old, with narrow lanes, small shrines, family homes, and local markets that together form the living heritage of Vrindavan. But my lords, this sacred heritage also comes with challenges. The area is congested and crowd management has always been difficult. Unfortunately, in August 2022, this vulnerability came to light tragically. During Janmashtami, celebrations, a stampede occurred at the temple, and in that chaos, two lives were lost and many others were injured. It was an incident that shook the confidence of devotees everywhere. In response, several PIs were filed before the High Court asking for better crowd regulation, medical facilities, and evacuation systems. However, instead of addressing these issues through proportionate and conservative measures, the state proposed a drastic solution, the Banki Bihariji Temple Corridor Project. This project, modeled after the Kashi Vishwanath Corridor, involves demolishing nearly 300 structures, acquiring 8 acres of land, and displacing hundreds of residents and small businesses that have been part of Vrindavan's identity for generations. The High Court directed the states to go ahead with this project, prioritizing safety over heritage and livelihoods. But my lordship, but your lordship, this discretion comes at a heavy cost. Over 200 million families face eviction, around 500 small businesses stand to be destroyed, and centuries old heritage structures risk permanent damage. All this without adequate consultation with those whose lives will be upended. The concerns are not limited to livelihood or culture alone. The Yamuna flows barely a few hundred meters from the site, and unchecked construction would endanger the fragile river ecosystem. No environmental impact assessment has been carried out. No clearance has been obtained under the Environment Protection Act or Water Act. Equally, the Ancient Monuments Act has been ignored. No heritage approvals were sought, even though the project area falls squarely within a designated heritage zone. And then, Your Lordship, there is a question of property rights. People are being deprived of their land without lawful process or adequate compensation, violating Article 300A of the Constitution as well as the Land Acquisition and Rehabilitation Act of 2013. Many of these properties do not even have clear ownership records, which makes the acquisition process all the more arbitrary and unlawful. We did not deny the importance of safety, but the state's position that nothing short of this massive project can ensure protection is simply not correct. Reasonable, proportionate, and conservative reforms could have been implemented long ago. Instead, the state rushed into spending over rupees 300 crore on a project that disregards due process, environmental safeguards, and the rights of ordinary residents who have lived there for generations. That is why Govind Das, a lifelong resident and Sevadar of Vrindavan, along with other stakeholders, has approached this honorable court. The petitioners are not opposing safety. They are asking that it not come at the cost of displacing families, destroying heritage, and violating the law. In April 2024, we even sought a modification requesting only that the land acquisition be stayed until public hearings, environmental clearances, and heritage approval were completed. Yet the state continued to push forward without these necessary safeguards. This dispute, therefore, is not merely about one temple or one corridor. It touches upon the core of our constitutional values, the right of life and dignity, the right to worship freely, and the right to property, and duty to protect our environment and heritage. Recognizing this, Your Lordship have rightly referred the matter of a constitutional bench, and a high-powered committee has been formed to assess its wider implications. This, Your Lordship, is the factual foundation of which our appeal rests. The Council seeks permission to move to summary of arguments of issue number one.
You may proceed, counsel.
Whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy or is a constitutionally valid exercise to remedy systemic failure endangering life and safety. On the first issue, the petitioner respectfully submits that the Honorable High Court, while exercising its power under Article 226, has overstepped its jurisdiction. Judicial review, no doubt, is the bedrock of constitutional governance. It ensures that executive action conforms to constitutional mandates and that fundamental rights are protected. But, Your Lordship, what the High Court did here goes far beyond judicial review by mandating the execution of the Baki Bihari Temple Corridor project with specific details of demolition, land acquisition, and construction. The court effectively stepped into the shoes of the executive. It was not merely ensuring safety or issuing direction to frame a policy. Instead, it was prescribing a particular policy itself. That we respectfully submit amounts to judicial micromanagement. The role of the judiciary is to ensure accountability and legality, not to design infrastructure projects. Safety reforms could well have been secured through oversight, monitoring, or directing states to take a particular scale as this line between overhand governance and the constitution out. The council seeks permission to move to arguments announced for issue number one.
Counsel, you may proceed with the arguments for issue number one.
May it please the Supreme Court, humbly submit on behalf of the petitioner.
Are you not audible?
2 minutes are left for the first team. There is some problem in connection, maybe.
Mm. Others may step in if she is facing some difficulty since you all have worked in a specific issue as
I
well. So,
apologize for the.
no, not a worry, not a worry. Yes, yes, please.
It is humbly submitted on behalf of the petitioner that the High Court, by issuing a mandamus to enforce a specific temple corridor scheme, has clearly crossed the permissible boundaries of judicial review under Article 226. The judiciary undoubtedly has the power to strike down arbitrary and or unconstitutional executive actions, but it cannot go a step further and start designing, approving, or mandating the precise contours of public infrastructure projects. That power lies squarely within the executive's policy making domain. Here, by prescribing the Baki Bihari Corridor project in its entirely complete with demolition, land acquisition, and construction plans, the High Court assumed the role of a project planner. Respectfully, that amounts to impermissible judicial micromanagement. Your Lordship, we do not deny the tragic events on 19th August 2022 where lives were lost in a stampede. That incident indeed exposed systemic failures in crowd management. But the response of the High Court directing the execution of one particular corridor scheme disregard the separation of powers. The constitutional role of the court under Article 226 is remedial, not substituted. It
Sorry for the
ensures legality.
interruption. Only 1 minute left for the first speaker of the team, TC13.
So I would like to state some cases. In state of West Bengal versus Nuruddin, the Supreme Court clarified that mandamus compels performance of a duty, but it cannot replace the discretion of the statutory authority. Similarly, in Vijay Mehta versus State of Rajasthan, the court held that when an act lies in the realm of discretion, mandamus cannot compel a particular policy choice. These cases illustrate that courts may enforce duties, but they cannot dictate how those duties are to be discharged. Your Lordship, in the next case, it is also submitted, Your Lordship, we do not dispute that Article 20 2021 places the protection of life and safety at the highest constitutional pedestal, but that means adopted to secure that protection must remain within constitutional limits. For these reasons, we submit that the High Court's mandamus is an impermissible exercise in micromanagement and cannot be sustained as a constitutionally valid remedy. I would like to move to issue number two.
Councils, I have few questions for you.
Mr.
Because these
Lordship.
question rounds is not inclusive of the time granted to a team, correct? It's with not coming under the 25 minutes cap.
But you may
This is
continue, sir.
yes, yes. So, Council, my first question is, what is the scope of Article 226 itself? Do we have a limited scope, or it can go beyond its applicability?
Uh, Your Lordship, the scope of Article 226 is to provide mandamus. It can provide if the
Only mandamus?
contesting authority, no, Your Lordship, but the thing is that the particular judgment that the High Court has given under this writ, that is not permissible, and it is going far beyond the regulation of that is maintained under the Article 226. But the thing is, we are here to ask that if the whatever the High Court has stated for the project corridor that they have approved the corridor project,
Mhm.
that particular thing should have been proportionate
So,
to
according
what
to you,
happened.
Council, according to you, the High Court, the Honorable High Court of Allahabad, has directed the executive to uh, form a corridor that is the Baki Bihari Temple corridor, correct? As per your own statement. But
Yes, Your
if you'll
Lordship.
if you'll read para number fifth of the Moot proposition, it is rightfully written and submitted that the state of UP, that is Uttar Pradesh, in its submission before the court, acknowledge that minor irregularities. We can skip this line. The government proposed a large-scale Baki Bihari temple corridor. The facts of the case states that the government itself proposed one specific corridor for qua the formation of this specific corridor in construe with the Bake Bihari temple. Now, the High Court merely directs the executive department, that is the government of UP, to enforce the said proposition. Do you believe that mere direction itself, there was a A, there was a plan was already proposed by state of UP. B, there's a direction of the court to enforce it in a greater way, in a higher way, or let's say in a way that it just uh, forms the project in a much quicker way. So, what do you think, Council? That this direction is judicial oversight qua the use of Article 226? Council, can you hear me?
Speaker number one, are you hearing the honorable judge?
Prakhar, am I audible?
Yes,
You
you are
could hear
audible.
the question. Okay.
Yes, yes.
I hope I'm audible to the rest of the people as well.
Yes, yes, yes.
Am
Uh,
I audible?
Yes, yes, you are.
Your Lordship, the
It's completely
Your
fine. You
Lordship,
can
the
take your time as well.
government has proposed a project. But the thing is, the project that has been executed by that the direction has given by the High Court, it is clearly stated in Article 226 that the High Courts cannot use their writ jurisdiction to manage commercial projects or perform roles that are outside the court's competence and beyond its administrative functions. So that is merely a commercial project because the acquisition of 8 acres of land and then demolishing all those 300 infrastructures that have been built seems like generations near the Bhakti Vihariji temple that has been somewhere a quite lesser executive role could have been done The the whatever they could have taken the measures that should have been taken to control the crowd and manage their execution, that could have been done merely with a lesser that is proportionate to whatever happened.
Okay, counsel.
It is
Okay,
not.
that satisfies my question. We may move to issue number two. Thank you, counsel.
Whether the issue number two, whether the reconfiguration of temple approaches, alleys, and religious cross circulation routes implicates Article 25, that is freedom to practice, and Article 26, management of religious affairs, and if so, the correct test to distinguish faithful facilitation from unconstitutional interference. May it please this honorable court, it is respectfully submitted on behalf of the petitioner that the proposed reconfiguration of temple approaches, alleys, and circulation routes strikes the very heart of Article 25 and 26. The Baki Bihanshi temple is not simply a building. It is embedded in a centuries-old spiritual landscape of a narrow lanes, processional pathways, and intimate approaches through which devotees have for generations experienced darshan and performed seva. These routes are not matter of convenience. They are constitutes of the live practice of faith itself. To widen, reroute, or demolish these sacred approaches is therefore not merely an infrastructural act, but an intrusion into the constitutional conditions of worship and denominational autonomy. This honorable court has made it clear, beginning with Seshamal versus State of Tamil Nadu 1972, that while the state may regulate secular aspects, it cannot interfere with essential religious practices, processional routes, ritual access points, and circulation spaces in Vrindavan form an essential part of the practice of devotion. By reconstituting these, the state effectively alters how religion is performed, something no authority may do without violating Article 25 and 26. The factual record depends this constitutional concern. The corridor scheme adopted post the unfortunate stampede of 19 August 2022 and mandated by the Allahabad High Court in March 2023 contemplates demolition of over 300 structures, acquisition of 8 acres, and displacement of family and small business, sustaining the temple's economy. Such sweeping changes erase made organic alleys that pilgrims have traversed for centuries. This is not a neutral regulatory measures for safety. It is a wholesale reordering of sacred geography and redefines the religious experience itself. In the next case that I would like to state is the state of Rajasthan versus Kajanlal Panjawat, 1973. This court clarified that while the state may regulate trust property, it cannot divest religious denomination of their rights to administer such property. Similarly, in the case of Ratilal Panachand Gandhi versus State of Bombay 1954, this court underscored that the right to manage affairs of religion is constitutionally protected, subject only to limited grounds of public order, morality, and health. The present corridor scheme violates this delicate balance. It intrudes into matters of religion rather than merely regulating the secular aspect. The correct test in our respectful submission must be threefold. First, essential character test. Does the measure alter the manner in which rites and worship are practiced? If yes, it amounts to unconstitutional interference. Second is the proportionality and least restrictive means. Has the state shown that drastic reconfiguration is the only way to ensure safety and that less intrusive measures were tried and found inadequate? Here, only alternatives such as staggered darshan, token system, QR enabled entry, temporary diversion, and festival time traffic regulation were available but ignored. Third is the denominational autonomy. Were temple authorities and sevadars who hold constitutional rights under Article 26 meaningfully consulted? The record shows they were not. A unilateral redesign imposed by the state without consultation breaches denominational self-governance. The case of Venkataramana Devaru versus State of Mysore, which is of 1958, further supports this position. Article 26 protects denominational rights subject only to Article 25 2b, meaning the state may open temples for social reform but may not reconfigure how rituals and devotions are carried out. The corridor, by altering the spatial and ritual logic of worship, crosses this constitutional line. Your Lordship, the ecological, cultural, and livelihood dimension cannot be ignored. The scheme lies with the Yamuna floodplain, risk damaging protected heritage pathways, and displaces hundreds of families whose livelihoods are interwoven with seva and temple practices. Article 25 and 26 must be interpreted in a living context, where religion is not abstract doctrine but embodied communal practices tied to space, tradition, and livelihood. The appellant submits that the reconfiguration of temple approaches on circulation routes does implicate Article 25 and 26. Applying the essential practice, proportionality, and denominational autonomy test makes clear that the corridor project is not facilitation but unconstitutional interference. The court should therefore restrain such unilateral restructuring and instead require the state to adopt less intrusive, consultative, and reversible safety measures that preserve the integrity of worship while addressing public concerns.
Okay, Council. So I only have one question since because of the paucity of time, I cannot sketch away. One is when we read Article 25 and 26, it comes with a specific subjections subject to certain exceptions or subject to certain exceptions that subject to public morality, public order, and public health. All these
Lordship,
institutions can have all their functionings. They can practice and profess any religion, whatever they feel like. They can have control over land. They can have control over their religious autonomy and religious affairs. But these are the subject exceptions applied over it. How these exceptions or exemptions are not in violation with the regular practice.
sorry, Your Lordship,
How
I cannot get the
these, so all these subject exceptions that they're subject to certain exceptions. Exceptions are as to public order, morality, and public health. These three these three pointers. So whenever all these institutions will practice their own law, will practice their own religious autonomy, they'll be are under subject to certain exceptions. Or these are certain reasonable restrictions laid upon by the Constitution itself. My question is, and quickly summarize it, how all these three factors, this is public morality, public order, and public health, are not in effect with the regular practice as run by these regular religious institutions, the people accompanying the religious corridor. Yes.
Your Lordship, the stampede that happened on 19 August 2022, it is not something that happens like regularly, or that kind of crowd is not on everyday purpose. That basically happens during the festivals like Kartik Purnima, Janmashtami, or Holi. And during those particular times, the temple management and the state management could cooperatively form some measures like proper management, proper excavation, proper the people if the how the people will be evicted if something happens, proper medical facilities, proper management, force. That measures could have been efficient for the
Understood. I've
management
understood.
purpose.
I've understood. Understood the answer. We may proceed to the next speaker as because of the paucity of time, I'll have to rest apart, please. Yes. Who's the next speaker?
Yes, sir, from the same team. There
Okay.
is a second speaker.
For the issue number 3 and 4, correct. Okay.
Your Lordship, if your Lordship is well aware of the fact the
Yes,
Council says
yes,
for example,
yes, counsel. Yes, counsel. Please proceed.
Issue 3, whether the state's objective of crowd management and public safety, Article 21, justify large-scale recognition and redesign of an organically evolved sacred precinct when less restrictive alternatives staggered darshan
Counsel,
enable flow.
I'm so sorry for the interruption. Since I'm now well versed with the facts of the case, I would humbly request you to kindly only press upon the part of the arguments. So whatever your arguments qua or with regards to issue number 3, quickly summarize it for me.
On behalf of the petitioner, it is respectfully submitted that while the protection of life and safety under Article 21 is an undeniable constitutional mandate, the state chooses mean of securing this objective through large-scale demolition and redesign of the organically evolved sacred precinct of Vrindavan cannot be justified. The principle of proportionality governs the relationship between state objectives and methods adopted to achieve them. Any measure that restricts fundamental rights must be shown to be necessary, proportionate, and the less restrictive means available. In the present matter, the state has failed to demonstrate why alternatives such as staggered person timings, technologically enabled crowd flow systems, and festival time regulations, and enhanced security personnel cannot adequately address public safety without irreversibly dismantling centuries-old structures and cultural practices. I'd like to refer a case law on proportionality, where the cases of Ramesh Chandra Sharma versus State of Uttar Pradesh. The They defined the proportionality test by emphasizing the need for sufficient safeguards within the analysis, building on earlier jurisprudence. By applying the proportionality test, the courts ensure that state powers in managing crowds are not exercised arbitrarily, but are balanced against the fundamental rights of citizens to freedom of assembly and expression. The petitioner emphasized that the sacred precinct has developed over centuries as a living embodiment of faith and cultural continuity, where narrow alleys and adjoining temples, small shrines, and religious circulation routes from part of an indivisible spiritual experience. The redesign scheme proposed by the state by demolishing hundreds of houses, shops, and small religious structures does not merely regulate crowds, but rather re-engineers the religious experience itself. Such action exceeds what is reasonably necessary for safety, management, and therefore they offend the constitutional mandate under Article 25 and 26, read with guarantee against arbitrariness under Article 14. In effect, the state's justification of crowd management is employed as a tool for large-scale transformation that determines the very sanctity it claims to protect. As it further mentioned, that River Yamuna is just 300 meters to 500 meters away from the temple. The construction will harm the environment as well as there was no assessment for such danger was done. The case of MC Mehta versus Union of India, case 1988, known as Kanpur terrorism terrorist case. The landmark case where the Supreme Court ordered terrorists to save up effluent treatment and pre-treatment plants, mandating they be responsible for the waste, even if it means financial hardship. The court also stressed the constitutional duty to protect the environment and proposed relocating RDGS industries to less populated areas. By this case, I want to refer that the large-scale demolition is not needed in the Banki Bihari corridor. A small infrastructure development is needed for just entry and exit, by which the crowd can be controlled. And the government officers should be there to maintain the crowd and management to manage it. And the development which they are doing, due to which the local peoples will be suffering, they will be going in economic loss, and their household will be upheld. And the Ganga River, which is an historical river, that also will be polluted and which harm the people. Further, the alternatives such as staggered darshan timings, technology-enabled flow management through e-passes or digital queue systems, and target festival time regulations have been successfully implemented in other pilgrimage centers across the country. In the present case, despite these viable options, the state has chosen the most disruptive course of action, bulldozing residential neighborhoods, erasing age-old alleys, and reconstructing the organic character of the temple town. This reflects not a genuine necessity, but an arbitrary preference from grandiosity development, disregarding the lived realities of divorce, residents, and small shopkeepers who constitute the backbone of the religious economy. Further, the petitioner also highlighted that the state has failed to demonstrate why less restrictive measures were not considered or adopted before resorting to such drastic demolition. No meaningful study, consultation, or expert report evidencing the necessity of complete design has been placed on record. Instead, the scheme appears to have been driven an administrative convenience and aesthetic ambitions rather than genuine safety imperatives. This absence of evidence underscores the arbitrariness of the state's action and strengthens the petitioner's contention that the redesign is constitutional. I would like to state that the state has already spent 300 crores on the land acquisition and building of the infrastructure development. But the state should not invest that much of amount. They should have spend a less amount for the development. That's for the development of the entry and exit. And for the proper guidelines, it should be placed from where to entry and from where to exit. And it is also been respected that in like at the time of Shravan, like June to August, during that month, in this Banki Bihari temple, annual limit is given that 50 lakh people are coming. Whereas in this Jharkhand, you might have been known, my lordship, in Jharkhand, during Shravan month, around 70 lakh to 80 lakh people are coming for this devotion. But never we have heard that any stampede has been occurred there. The management of that state government is very well. But if this UP government
So
having
do we
this
have
much
any
of,
corridor in the specific temple which you're mentioning in Jharkhand? Do we have a
so
very
that
specific corridor as well which regulates the same, or you have maintained in the state of Jharkhand itself, they have maintained its natural sphere, not
yes, my lord.
actually interfering with whatever it was already there. Or you
Like I
have
was just referring, thus I was just referring that the government they are managing it very well, but the UP government they cannot manage it, and they are where where they are liable. The UP
got
government
it.
is liable for
Understood.
this stampede.
Understood, council. Understood, council. Do you have anything to add in issue number three, or can we move to issue number four?
So issue four,
You may proceed, council.
the council seeks permission to move to issue four. Whether the absence or inadequacy of meaningful public consultation, residents, shopkeepers, religious bodies, environmental experts, renders the decision-making process arbitrary under Article 40. It is respectfully submitted that the constitutional guarantee of equality under Article 14 is not confined to non-discrimination but extends to ensuring fairness, non-arbitrariness, and transparency in state action in matters that directly affect the lives, livelihoods, and cultural rights of local residents and devotees. The state is duty-bound to adopt a participatory and consultative decision-making process. The absence or inadequacy of such consultation renders the entire exercise arbitrary, thereby fall of Article 40. Further, the petitioner emphasized that the temple town is not merely an administrative unit, but a living ecosystem that has organically evolved through centuries of shared community practices, narrow alleys, residential clusters, temple-linked shops, and small streets together, from a socio-religious fabric that sustains both the spiritual and material lives of thousands. By failing to consult the residents and shopkeepers who have long supported the religious economy, the state has overlooked the very stakeholders whose livelihoods and rights are directly jeopardized. Similarly, the exclusion of religious bodies from consultation betrays the consultation recognition under Article 25 and 26 that religious denominations are entitled to manage their own affairs. The absence of their participation renders the redesign arbitrary as it transforms religious practices without the input of those who embody and sustain them. I would like to refer the case laws. In Kamakhya Temple development case, the Guwahati High Court ordered the Assam government to respond to PIL challenging the construction of the Kamakhya Corridor project, citing concerns about potential violations of environmental and protection procedural safeguards, as well as negative impacts on local heritage and water resources. Through the project's goal is to improve access for pilgrims, not to provide personal benefit to the government. Further, the it is also argued that the consultation in this context is not a merely procedural necessity, but a substantive constitutional element. And Article 14 mandates that state action must not be arbitrary or capricious, but must be informed by reasons and fairness. The Supreme Court has repeatedly held that the rule of law demands participatory decision making, particularly when large populations are affected. In the present case, where hundreds of homes and shops have been demolished and livelihoods seriously disrupted, the absence of a transparent process of dialogue and consent demonstrates a clear departure from the constitutional mandate. Decision imposed without consultation and inherently unreasonable and thus constitutional under Article 40. I would like to refer a case in the case of Keshav Prasad versus Commissioner and Special Officer, Hyderabad and others, where a division bench of this court, while dealing with the case of demolition of construction for the purpose of a road widening, observed that in view of the constitutional mandate under Article 308, the right to property cannot be taken up except in accordance with law. Further, the petitioner argued that the state has invoked public safety and crowd management as blanket justification without considering the rights and concerns of those most affected. By excluding stakeholders and from the process, the state not only deprived itself of valuable insights and less disruptive alternatives, such as staggered darshan or festival time regulation, but also undermined democratic legitimacy in decision making. The unitarianism is the very definition of arbitrariness under Article 14 and violates judicial intervention. The petitioner argued that whatever the government is doing, the government should consult with the environmental experts and the people's really staying there. But the government failed in these all things, and the government unnecessarily has used its arbitrary power and started demolishing the local residents. And it is also known as that the historical sites, whereas the government has argued that that plan integrates modern design with heritage elements. The people have some sentiments attached with the temple, So that if the government will modernize it, the pilgrims will not come to the temple to visit. So that I request the lordship that file the corridor scheme should be stopped, and the small development is just needed. Your lordship, the council seeks permission to move with the prayer.
You may, counsel.
In the light of the facts of the case, issue rates, arguments advanced, and authorities cited, the Council, on behalf of the appellant, humbly pray before the Honorable Supreme Court of India to kindly judge and declare that the High Court's mandamus under Article 226, directing implementation of a particular corridor scheme, amount to impermissible micromanagement of executive policy and is ultra vires the constitutional limits of judicial rule. Number two, that the reconfiguration of temple approaches, alleys, and religious or circulation routes violates Article 25 and 26 by interfering with the essential freedom of religious practice and denominational engagement of religious affairs. Number three, that the state shall consider and adopt less restrictive alternative for crowd management and public safety, such as staggered darshan, technology-enabled flow, and festival time regulation, instead of restoring to discriminate large-scale demolition and redesign of the sacred precedent. Number four, that the absence or inadequacy of
Sorry for the
public
interruption. The time is concluded for the speaker too.
This was I about to mention that. Okay, we may proceed with the other speakers from the side of the respondents. Only if there's a slight change, we'll be first hearing the issue number 3 and 4 from the side of the respondents, followed by issue number 1 and 2. So whosoever is
Now I request the respondent to start with the
Thank you,
proceedings.
my lord, sir.
Team 2, team code 06, Cooperative School of Law. Yes,
Sir, can
you
you hear?
Team code 06, there's only one small modification. We'll be first hearing with the issue number 3 and 4, followed by issue number 1 and 2.
Okay.
Yes, you can start with the proceedings.
So can you hear me?
Yes, you're audible.
If your lordship is well versed with the facts of the case, the council seeks a permission to move on the issues raised by the petitioner in this case.
Allowed. Please go ahead.
The first issue is that whether the High Court mandamus under Article
Counsel, I
220.
believe you did not hear me. I said we'll be first proceeding with issue number 3 and 4. So whoever from your side has prepared on issue number 3 and 4, we'll be first taking with issue number 3 and 4, followed by issue number 1 and 2. So we're starting with issue number 3 and 4.
Okay, sir.
This is not allowed in the middle of the court proceedings. You have to switch on your camera and the mic.
Sir, can you hear me?
Yes, you're audible. Please go ahead with issue number 3.
Whether my lordship, whether the law state's objective of crowd management and public safety under Article 21 justify large-scale demolition and redesign of an organically evolved sacred precinct, when less alternatives such as staggered darshan, tech-enabled flow, festival time regulation exist. The council seeks permission to move on to the arguments of third issue.
You may, counsel. Please go ahead.
Much of your lordship. On behalf of the respondent, the state of Uttar Pradesh, it's respectfully submitted that the proposed redevelopment of Bange Bihariji Temple precinct is a constitutionally valid, proportionate, and necessary measure. This project is not merely a matter of policy convenience, but a constitutional duty following from Articles 21, 47, 48A, and 49. First, under Article 21, the state is under a positive obligation to protect life and ensure safety in spaces of mass congregation. The tragic stampede of August 2022, which claimed innocent lives, exposed the structural collapse of the precinct. Your Lordship, you have consistently held in Ray Remali Maiden and Francis Colery Mullin case that the right to life includes not just existence, but safety and dignity. An unsafe pilgrimage is a denied pilgrimage. The corridor project dictates decongest lanes, creates regulated entry points, exit and entry points, and provide emergency evacuation routes precisely to secure the article right under Article 21. Secondly, Article 47 obligates the state to improve public health and safety. Though it's a directive principle, the court in Ratlam Municipality and Pachim Benga case had read it is an enforceable governance duty. The present precinct, narrow, overcrowded, and devoid of medical or emergency facilities, is a hazard. The redesign directly fulfills the constitutional mandate. Third, Article 48A, which enjoins environmental protection, is also served. The project integrates pedestrianization, waste management, and ventilation improvements. As this court held in MC Mehta and Subhash Kumar, a clean and safe environment is a part of Article 21 itself. The redevelopment is not at all the cost of the environment but in harmony with it. Lastly, Article 49 requires protection of monuments and heritage. Safeguarding a monument cannot mean allowing unsafe access. In INTSH and mostly recent in Kashi Vishwanath Corridor project, redevelopment was upheld when heritage was preserved with the ensuring safety. The Bange Bihari project follows the same principle. The sanctum remains untouched, with the dangerous lanes are redesigned to save lives. In summary, Your Lordship, this project harmonizes safety with sanctity. It respects faith while correcting infrastructural failures that have already claimed lives. The respondents submit that the challenge must fail because Constitution does not demand a choice between life and faith. It demands that the state secure both. The council submits the arguments. The council seeks permission to move on to the next issue.
Counselor, I have a couple of questions for you with regards to issue number 3. One is, if so, I believe when it comes to a state responsibility to perform two obligations, one is that to protect one heritage site which has a very specific importance towards a group of people, specifically a very big regional group of people whose lives, whose livelihoods, whose sustainability, and whose religious belief depends upon the very existence of the natural premises of that whole that natural premises of the very statute or stature. And herein it's Baki Bihari Temple, wherein a lot of maybe thousands of lives are completely dependent on its sustainability. So when we speak about the formation of the corridor itself, and whereas there was multiple other less restrictive areas which the state could actually use, let's see, staggered darshan, one, tech-enabled flows, and festival time regulation, wherein a development of specific gates. How would you confer or how would you summarize your arguments as to when it's about to choose between the two obligations, where maybe a interest of a specific group may be larger than what is there for the development or redevelopment? How should state proceed with that?
My lordship, in this case, it's not a case of any, it's not the interest of any special groups. In the festival season, about 50 lakhs devotees come to this Vrindavan for this, in this Kashi Vishwanath temple, not Kashi Vishwanath, Bange Bihariji temple. And the same project is done in the Kashi Vishwanath corridor project. As there also, they had made the project successfully using the corridor project, and we are making the same project here without touching any historical monuments. We're not touching any historic monuments, and so also the public safety is the first priority of the government. Actually, in the festival season, about 55 lakh devotees are coming to this temple, and so they're hugely overcrowded and congested areas. So there is no proper facility for the sanitation and medical facilities if they occur. So for making all secure, as the devotees, not the residents there, all the peoples, securing all the peoples, that's the devotees and the
Okay,
residents.
Council. Okay, Council. That satisfies my question. We may proceed to issue number 4.
My Lordship, the respondents submit the Bangi Bihari Temple Corridor project fully complies with Article 49, which obligates the state to protect monument and places of historic importance. The sanctum and court temple structure remain untouched. Only the narrow, congested peripheral lanes are being redesigned to ensure safety accessibility. Statutory safeguard under LARR Act 2013, including consultation and rehabilitation measures, have been strictly followed in this case. The balance between heritage preservation and public safety is at the heart of this project. Judicial precedents affirm this approach. In Ramashram or Autocracy versus Union of India, in this case, the court recognized that cultural heritage must be preserved, but not all the cost of public interest. Similarly, in INTACH Union versus Union of India, development near heritage site were permitted as long as it respected cultural aesthetics and due process. Further, in MC Mehta case also, the court stressed the need for an integrated approach, that is safety, environment and heritage together. Here, to the state has engaged conservation architects, adopted heritage-sensitive designs, and ensured minimal intervention. Far from damaging heritage, the project safeguard the temple precinct by removing congestion, improving environmental quality, and securing devotees' safety. Thus, the project represents on destruction of heritage, but its protection in a modern context, harmonizing the state's obligation under Article 21, 48A, and 49. The council submits the arguments. If your lordship is well versed with the argument, the council seeks permission to move on to the prayer.
Council, only one specific query, or let's see, I'll say it's a feedback that unless and until the court hears all the issues and arguments over the all the issues, we cannot directly jump into the prayer. So we'll skip the prayer. After the conclusion of first two issues, we'll move on to the prayer. Okay, Council?
Much obliged, lordship.
Yeah, we may start with issue number 1 and 2.
Let's start with the.
So can you hear me?
Yes,
Yes.
Council. Please go ahead.
May I please this honorable court, myself, counsel number 1, along with my co-counsel number 2, representing the respondent state of Uttar Pradesh in matters between the Govindas versus state of Uttar Pradesh and others. The council seeks a permission to address the bench collectively as your lordship. The council seeks a permission to move on the facts of the case.
Council, we may skip the facts of the case. We can directly proceed with issue number 1 and 2.
If your lordship is well versed with the facts of the case, the council move on the permission to move on the issues raised by the petition of this case.
Please go ahead, Council.
Much obliged, your lordship. The first issue is that whether the High Court mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy or is a constitutionally valid exercise to remedy systematic failure endangering life and safety. So may it please the Honorable Court, the petition contended that the Honorable High Court overstepped its jurisdiction by directing the implementation of Bange Bihari Temple Corridor project. However, the respondent submits the High Court intervention under Article 226 was a constitutionally valid because a proportionate exercise of judicial power is aimed at safeguarding human life and fundamental rights. First, Article 226 empowers High Court to issue writs not only for enforcement of fundamental rights but also for any other purposes. So, the writ of mandamus is lies to compel the state to perform duties it has failed to discharge. So here, a tragic stampede of August 2022, which resulted in deaths and injuries, and revealed a systematic failure of the state to protect the lives of devotees under Article 21. So the High Court was duty bound to intervene. So second, this was not a judicial overreach but a judicial necessity. In MC Mehta versus Union of India 1987, this honorable court held that the courts may issue detailed directions where state inactions threatens public health and safety. Similarly, in Vaishaka versus State of Rajasthan 1997, binding guidelines were framed to protect the fundamental rights in the absence of legislation. So, if guidelines to prevent the workplace harassment could be judicially crafted, the surely directives to prevent the recurring loss of life is in a religious present are justified. So, the High Court did not design or micromanage the policy. It merely directed the state to implement the very plan the state itself had proposed. So, the Banke Bihari Corridor project. This was an exercise in accountability, not a judicial policy making. As held in State of Uttarnachal versus Balwant Singh Chaffal 2010, court may actively intervene in PIL spills of the grave public importance when executive failure endangers fundamental rights. So, the High Court carefully balanced the competing rights. While heritage protection under Article 49A, 48A and 49, the property rights under Article 300A are significant. They cannot override the fundamental rights to life under Article 21. So the state has committed to lawful and land acquisition and rehabilitation under the LARR Act 2013 with 300 crore earmarked, thereby ensuring compliance with the Article 300A. Therefore, my lords, the impugned mandamus was not judicial overreach, but a constitutionally mandated safeguard against the imminent danger to human life. The High Court acted within its power under Article 226 to ensure that the state fulfills its constitutional and statutory duties. The council submits the argument. The council seeks permission to move on to the next issue.
Council, before we move on to issue number 2, my question is, while exercising a writ jurisdiction as to Article 226, can the court, for the time being, remove the procedural irregularities or regularities without inconstrue with the current standards as to how the project is to be worked, how the project is going on without any specific public consultation that the state should have done, without any proper management as to the rehabilitation and resettlement? Can the court, can the judicial forum under Article 226 exercise its jurisdiction so as to grant a permanent or a temporary systematic development?
Your Lordship, the High Courts issued a mandamus to remedy systematic failure, which has been threatening to the life of the peoples in the peoples of the Banke Bihari project or the devotees who were coming to there for their religious purposes. So the state retains the flexibility in execution. So the judicial directions ensure the accountability while respecting the powers they have. And the project does not touches like any secular infrastructure. It's widely like only setting of emergency access public amenities without altering the rituals, priestly duties, anything, something like that. So statutory consultation under LARR 2013 environmental
Noted,
experts.
Council. We can kindly proceed with issue number 2. We can quickly just be very thorough.
Much obliged, Your Lordship. May I please the Honorable Court? The petitioners argue that the reconfiguration of alleys and approaches interference with Article 25 and 26. However, the respondents specifically submits that the Banke Bihari Temple Corridor project does not amount to unconstitutional interference, but rather constitute a faithful facilitation of religious freedom. First, Article 25 and 26 are not absolute. They are expressly subject to public order, morality, and health. In Acharya Maharajistri Narendra Prasadji, 1975, in this case, the Honorable Court held that no right can be enjoyed in a manner that endangered others. So the stampede of August 2022 demonstrate that the present conditions are a threat to both public order and health. To suggest that unsafe, antiquated infrastructure is beyond regulation would be contrary to the spirit of Constitution itself. So second, the state's action concerns secular matters, not core religious practices. In Durga Committee, Ajmer versus Sayyid Hussain Ali, 1961, this court clarified that Article 26B protects only essential religious practices, not secular administration or property management. Likewise, in Shirur Moot, 1954, in that case, this court distinguished between the rituals of worship, which are protected and associated secular activities, which the state may regulate under Article 25, Clause 2, Subclause A. Here, the reconfiguration of the lanes and provisions of the safety infrastructure relate solely to crowd management, not to rituals, timings, or religious doctrine. So, third, the project enhances rather than restricted the right to worship. An unsafe pilgrimage is a denied pilgrimage. By providing wider paths, emergency access, and regulated access, the state is enabling devotees to practice their faith with safety and dignity. This facilitation does not interference in a Church of God versus KKR Majesty Colony 2000. In this case, this court held that religious freedom cannot be exercised in the manner that endangered others' fundamental rights, particularly to right to life. The same principle apply here. Safety must prevail over the sentiment. So, therefore, my lords, the state is not dictating how worship should occur. It is ensuring that the path to worship is not a death trap. The project is constitutionally valid, consistent with public order, and strengthens rather than diminishes the freedom of religions, Articles 26 and 29. The council submits the arguments. If your lordship is well versed with the first and second issue of arguments.
Yes, yes, counsel.
So the council seeks the permission to call upon my co-counsel for the prayer.
Formal. Yes, counsel, please proceed.
Much obliged, Lordship. It is hereinafter most humble, prayed before the Honorable Supreme Court of India that in light of issue raised, arguments advanced, authorities cited, and pleadings made, this Honorable Court may be pleased to adjudge and declare that the High Court's mandamus under Article 226 directing implementation of the corridor scheme is a constitutionally valid exercise of judicial power in public interest to remedy systematic failures endangering life and safety and is therefore enforceable. That the second one, that the reconfiguration of temple approaches, alleys and religious circulation routes does not violate Article 25 and 26, but instead meets the test of faithful facilitation without unconstitutional interference. That the state's objectives of crowd management and public safety justify large-scale demolition and redesign as necessary to fulfill its positive obligation under Article 21, that's public safety. The adequate steps of meaningful public consultation with the residents, shopkeepers, religious bodies, and environmental experts have been and will continue to be undertaken in line with procedural safeguards, rendering the decision-making process reasonable and non-arbitrary under Article 14, and to grant such offer relief as in this honorable court may deem fit in the interest of justice, equity, and good science. Much obliged, my lords.
Okay, counsel, thank you so much for advancing your arguments. All the counsels, you guys spoke really well. Now, in terms of the feedback, it was very wonderful to hear all you off. And only feedback which I would to press upon here is just be a little more concise as to the facts, as to the issues, and as to your arguments.
Your Lordship,
If you're reading,
sorry for the interruption.
yes,
5 minutes are provided to both the teams for the rebuttal.
okay, okay.
Each
Oh, I'm so
speaker
sorry. I'm
of
so
one
sorry.
team will rebut.
Yeah, we may then we may then proceed with the rebuttal if there are any
Yes,
rebuttals.
then we will start with the first team now. Speaker number one from the first team,
Speaker from TC31.
TC31.
Are you guys having any rebuttable questions with
Question
TC06. You're not audible.
for
Can you
TC06.
please return?
That is,
Yeah. Yes, you are. Yeah.
am I audible now? Question number one is, if every tragic incident allows courts to dictate construction projects, would that not be collapse? Would that not collapse the separation of powers? And the second question is, can the state justify why safety could not be secured by measures short of demolition and permanent corridor construction?
Who's coming from TC06 to advance the answer to these questions?
Any speaker from the
My
team 2 for the
lordship,
rebuttal? Yes.
my lordship, I please my co-participant to please once more the question, please.
Okay. Council, can you
In my
repeat the
first,
questions, please?
if every tragic incident allows court to dictate construction projects, would that not collapse the separation of power? This is my first question. And my second question is, can the state justify why safety could not be secured by measures short of demolition and permanent corridor construction? As there were no prior, any any measure were taken prior this particular proposal of the project. So why didn't the state care about much lesser measures rather than just proposing
Sorry to
a big
interrupt.
project?
Your voice is not clear, so I can't.
Okay, I'll just summarize the question for you. One is,
Okay.
supposedly, if there's any tragic incidents, right? Like in this case, there was a tragic incident, two people lost their life because of the stampede followed in the year 2022. Correct. So after the tragic incidents, can the state, via approaching the judiciary, and as per the direction of the judiciary to proceed with the construction of certain corridors, would that, in true sense, violate the separation of power, the principle of separation of powers? Question number two, can you hear me? Was that question
Yes.
understandable to you?
Yes.
Okay. Now the question number two is, sorry, counsel, what was the question number two?
So question number two is, can the state justify why safety could not be secured by measures
Okay.
short of demolition
Yes,
and
yes, yes.
permanent corridor
The question number two is, instead of reconstruction of the whole project itself or building a corridor with regards to the Baki Bihari temple, why aren't the smaller measures like more construction of gateways, exit gates, entry gates, the implementation of smaller measures which could be a permissible from the point of view of the petitioners, would be far more reachable, that will create a balance between the two. I hope the questions are understandable to you, counsel.
Much obliged, my lordship. I understood the question of my
Yes, yes.
co-participant. The High Court issued the mandamus to remedy of systematic failure threat of life. As in this case, in August 2022, on the festival time, there two persons' lives had gone, and though the High Court issued a mandamus to remedy of systematic failure of threat of life, the state retained flexibility in execution, and judicial direction ensures accountability while respecting separation of powers, and also article religious freedom under article 25 and 26. That's the project though only uh, make the didn't touch any historic monuments or heritages. They only making the project, that is the same corridor project in the Kashi Vishwanath. That's all. The other monuments are not touched
Counsel,
in this case.
I believe you could not understand the question. The question was, now the state wanted to build, as you wanted to build this corridor, and based upon the directions given by the learned High Court, you proceeded with the execution of the project for the corridor. So will that the direction of the court while stepping into the works of the executive, that is you, would that amount to separation of power or not?
It will not amount to the separation of powers.
Okay, counsel. And if we can quickly move to question number two.
Sir?
We can quickly move to the question number two, whether there are, so supposedly, if there are far more reachable measures which could create a balance between the two, between the respondent, between the petitioners, that instead of building the whole corridor itself, a smaller measures like construction of more gateways, exit gates, and entry gates, or the smaller measures, why the state could not proceed with the smaller measures instead of just revamping the whole of the alleys of the Baki Bihari temple.
My lordship, in this case, the small gates, as we construct in small gates in this area, in the Vrindavan, this area, the festival times, the around 55 lakhs of devotees are coming to this area. And if we construct small gates for gates in entrance and exit gates, it will not work in this place, because as this too much crowded area, and so we need this project, the same project as in the Kashi Vishwanath corridor project. That because in this project, after this Kashi Vishwanath corridor project, the place in the Kashi, it worked and crowd has been controlled. As we are looking the same in this case.
Okay, council. Okay, council for TC is 31. Do you have any sub-rebuttable? I believe sub-rebuttable questions are not permissible, but I hope the questions were clear. The answer was clear to both the parties, both the councils.
The Lordship, I was having a discussion.
You
Can I
have
speak?
a sub-rebuttable question.
Yes, my Lordship.
Prakar, do we have time for a sub-rebuttable question?
So last 3 minutes are left for this purpose, for the sub-rebuttal.
Okay, council. We may proceed with a sub-rebuttable question.
The Lordship has respondent has mentioned in the issue number 3 and 4 that they have not touched any historical movements that they have mentioned, but it's clearly mentioned in issue number 9, facts number 9, that the construction activities would impact protected monuments and sacred areas and pilgrimage routes that are integral to Vrindavan's religious identity. That will impact the impacted protected monuments. And where they have also mentioned that washroom facility, where the pilgrimage has only demand of the crowd management system and creation of safe entry and exit channels for large number of pilgrims. So there is no need of washroom facilities and all. For that, all there are hotels and government
So
residence places are there.
what is the sub-rebuttable question, council?
Like they have mentioned this all points which is of no use, and they have also maintained Article 49, which states that protection of monuments and places and objects of national importance. It shall be the obligation of the state to protect every monument.
Okay, council. Do you have anything else to add on?
No, my
Okay,
no, Your
council.
Lordship.
Your Lordship hereby requested to please provide the valuable feedback to the council.
Okay, yes. So that I would request everyone to switch on their cameras if
Oh,
you guys can.
my lord, we also
Yes.
want the time for rebuttal.
Prakar, do we have time?
No, sir, time is not right. But as per the
At
description
least
of
we'll give him 2 minutes. So 2 minutes, council.
last 2 minutes for
Yes.
both the teams for the rebuttal or a sub-rebuttal.
Yes, council.
Yes, my lordship. My first question is that you claim the High Court exceeded its power, but is in judicial review under Article 226, specifically designed to remedy violation of fundamental rights, especially when public safety in this state. And also, the second question is: petitioners argue that environmental experts were not controlled. Consulted and where EIA reports and heritage clearness obtained.
Yes, who's coming from TC number 31 to answer the query?
So they say, as the my opponent stated, that they are. It's not like the exceptions are there, and it's not the government. The High Court is not exceeding the law, but it is clearly there in Article 26 that the state can regulate religious institutions to ensure better administration
Sorry for
and
interruption,
management,
my
as in
co-participant.
cases
It's not
where
clear.
acts were passed.
Yeah,
Challenge
it's
Your
not
the
clear
voice
to
is
me as
institution.
well.
breaking. Your
It's not
voice is
clear.
breaking.
It's not clear.
It's not clear to me as well. Yeah.
Uh, shall I repeat?
Council, what
Yes, yes, yes.
else we can do then? You may rejoin. We'll see if it's audible. If not
Sure.
audible, then you can just write your answer in the drop or in the chat box itself.
Sure.
So we'll do that. Yeah, we'll just wait for her for a minute. If she's audible, then it's fine, or else she'll write the answer in the Dropbox itself.
Hello, am I audible now?
Yes, yes, Council.
Yes, you are audible now.
Okay, so the question was regard to the mandamus. But under Article 25 and 26, it is clearly stated that the state has only the right to administer and manage in the facts that the public morality, public health, and public safety is harmed. But there was only one such incident where the tragic stampede happened. And can you just say that because of that one particular incident, one particular tragic stampede, that is not something that happens regularly? It's in years and years, it has happened only for once. Can you say that such such major changes, such major reconfiguration was actually required just to save some few people lives? You're just establishing 300, more than 300 people, 300 families and businesses. Don't you think that their right is violating? You are violating their right as well, because they have they have settled over there since generations and generations. People, pilgrims who comes there, they have an emotion, they have and sentiments that has been like throughout the years. It's not something that happens regularly. So why to spend rupees 300 crores on such big project when there are some lesser measures that the state could have taken, that they could have cooperated with the society, that the community of the temple, and through those measures, the stampede could have been regulated.
Okay. So, Council from TC06, you have 1 minute to address the question. It was a question, but now it's a cross question to you. So just address, and this is the final question because of the positive time. I'm actually very much interested in these arguments. I'm actually enjoying it a lot, but due to paucity of time, I'm just allotting one last minute to TC06 to advance its arguments over these questions, and it could be decisive.
Much obliged, Lordship. Thank you for your giving time for me. And I'm asking my co-participant, that's is there you are saying that
No,
so only
not in terms of question, Council, not in terms of question. As I said, I'm actually enjoying these arguments a lot, but because of paucity of time, I'll have to actually rest it. So the question put upon by her is, hereby you're trying to save those two people in, so you're making a reference of those people who actually lost their life because of the stampede, whereby you now invested 300 cr for this investment for this corridor, which can actually scrap or rehabilitate almost more than 300 families. So how would you justify that? That is the question put upon by the council for the petitioners to you. And you have 1 minute to address it, and iske baad we are not taking any questions.
SAFO protect the right to life under Article 21.
Mm-hmm.
So everyone's life is important for the state,
Correct.
is it?
Nice.
So we are doing that under Article 21. Stamped expert provide its report international standard for mass gatherings can confirm that narrow historic lands lanes are unsafe for so the lakhs of pilgrims annually when
This
they
is the
are.
report by UNESCO. You've cited some report.
My lord,
Have you cited some report which says narrow lanes can be dangerous to people?
uh,
Is
that's
it a
from the
report or
international
it's your
standards.
argument?
It's from the international standards
Okay,
reports. Much obliged, my lord.
that's it. Okay, councils. So I hope there's no more questions in the room, and even if there's so, we are actually time bound. I would actually love to hear all these questions, the arguments. As much as I love these arguments and all the arguments over these issues, it's amazing issues, amazing arguments by all of you. Only feedback which I would like to mention is, so whenever we are speaking, try to master the use of pause while you're arguing. So once you argue in a straight way, try to give yourself some pause so that you can think, you can articulate your arguments, and it can be better representative. Number two is, instead of just reading all these notes which you have prepared, all the arguments, then the whole purpose of all these arguments is that since I'm carrying your memorials, so I can read all of your research, I can read all of your arguments, that you do not necessarily have to just read out, correct? So the whole purpose of these arguments is to gather your thought, whatever you have done, whatever you have researched, just try to think upon all your arguments and then addresses to the court. And that's you'll eventually do when you'll enter into the profession. Uh, Fortunately, unfortunately, do not have the memorials as of now, so I cannot comment on the memorials. But anyways, you guys can reach out to the organization committees. I'll just try to, if time allows to me, I'll just try to point out all those corrections, all those modifications which you guys can work on in your memorials. Once it is available to me, I'll just try to put all the notes in all your respective memorials, and I'll send it to the OC member, and you can thereby connect with the OC member to get your updated or the memorials with some notes that may help you in the long run as well. Other than that, so there's once you're addressing the court, uh, whenever I ask you a questions, whenever I permit you to speak, since I am a very flexible judge because I'm not a very orthodox judge, so I actually ignore it. But supposedly you are also preparing before some other councils, some other judges as well. They might be rigid with their approach. So what you guys can do is, after every statement, whenever the judges ask you, you have to just speak, much obliged, much obliged, much obliged. I humble. I am completely honored. So all these terms, it's not gonna help you in this shorter long run, but it's gonna also help you in the longer run once you enter into the professions. So I remember whenever I appear before the courts, now it actually helps me a lot because I have done few moods wherein I have mastered the use of the word much obliged. So even if I didn't know the arguments, even if I didn't know how to answer the question specifically asked by the judge, I always used to say much obliged, much obliged, much obliged. So that actually helped me in the long run as well. Other than that, it was fairly good arguments by both the teams, good research, good articulation, and you guys all are very thorough with your facts, very thorough with the law. It's just the presentation which you guys eventually learn over time. I believe all of you guys are in early years of a law school, maybe second or third, or maybe fourth. So even though otherwise you guys have a lot more time, so you guys can explore it more, try to participate, it, try to read a lot, try to learn a lot. And that's it from my side.
Thank you, sir.
I request the participant to kindly leave the meeting room and would request the judge to please stay in the room. Sir, you are requested to fill the scores on the score sheets.
Have you shared it with me?
I will coordinate with my team and I will share. Okay.
Okay, Prakhar.
Okay.
Good to connect with you. Wonderful, yeah.
Okay, sir.
Okay, keep learning. Bye. Bye.
Bye.